Thank you, Judge Sebutinde, for this invitation to address this conference today. It's a pleasure and an honor to introduce to you the Permanent Court of Arbitration and its role in conjunction with the protection of human rights. I'm from the triple P generation, which is to say pre-PowerPoint presentation. So if all goes well, I'm lucky. If you see what I see, that's the picture of the Peace Palace. And that's a good start for my presentation, because the building that was created in 1913 is obviously very well known as the seat of the International Court of Justice. But I don't have to tell you that it was created to house the Permanent Court of Arbitration, which was created in 1899 by a conference that was held in The Hague. I think if I skip one or two, then you see here the structure of my presentation, origins of the PCA, then the PCA in international human rights law, international arbitration, and access to remedy at the end. But here is the 1899 convention, which contains a few quotes of interest to our subject of today, including the reference to the welfare of peoples. This is a copy of the deed of Andrew Carnegie, who granted the money to build the Peace Palace. If I'm well informed, it was quite an amount of money, but not enough to build the second tower. So that's why this building is a bit unbalanced, but it's a very pleasant environment to work, and I'm very pleased that the PCA has the honor to work side by side with the International Court of Justice. Maybe a few words on its origins and its actual activities. The PCA was created as an intergovernmental organization. At present it has 116 member states, 117 shortly, when Georgia will join us. It was created to deal with interstate disputes, but has moved over time, thanks to its flexible character, to arbitrations that involve other than states. And in fact, it, I think, is an illustration of the development that one can find throughout international law, that states are no longer the exclusive actors in international relations. In fact, through a variety of steps, states have accepted and have authorized, in fact, individuals to initiate arbitration against another state or another public entity or intergovernmental organization. The range is from investment protection treaties to service contracts involving an intergovernmental organization for, say, ITC services or stuff like that. That is done in practice through either contracts or through national law or through multilateral or bilateral treaties. 3 words on arbitration. It's final and binding. There's a lot more to be said about it, but final and binding will do for now. It is very flexible as a mechanism. It allows parties a maximum of involvement in the process. Parties normally appoint their own arbitrators. Those 2 or 4 arbitrators, or 6 sometimes, then are appointing the presiding arbitrator. Flexibility also in respect of the timing. Parties can agree to keep it short. They can decide to do it elsewhere than in The Hague. Lots of elements that allow arbitration to be very close to the parties. That is not to say that it's only been a success story, although at present the PCA deals with some 95 cases, including some involving states. Here we are. But obviously there have been successes, like the increased number of cases that can be dealt with in this way, notably in the area of investment protection. But there has also been criticisms. Criticisms in the sense that civil society is suspicious of the confidential nature of international arbitration, which sometimes excludes third-party interventions by NGOs, but yet which has important public policy implications. Recently, the same civil society has protested against the TTIP negotiations, the negotiations between the US and the European Union member states on a trade and investment partnership, on the basis that it would compromise regulations that protect health, workers' rights, consumer safety, and the environment. A number of Latin American countries have denounced the exit regime. That's the organization linked to the World Bank that deals with investment disputes. Bolivia in 2007, Ecuador in 2009, Venezuela in 2012. And even would-be US presidential candidates such as Hillary Clinton have made clear that in reviewing NAFTA, she would, and I quote, take out the ability of foreign companies to sue, unquote, the US because of worker protection laws. But could there be a more positive and productive relationship between international investment law and international human rights? And I'm approaching the subject of today. In 2012, I moderated a panel in Mauritius, the Mauritius International Arbitration Conference, entitled, that's a mouthful, Sovereign Policy Flexibility for Social Protection, Managing Uncertainty Risks in International Investment Agreements, in which Dr. Diane Diciato argued that while regulatory predictability is a key goal of international investment agreements, an investor's legitimate expectations do not need to constrain states' compliance with the International Covenant on Economic, Social and Cultural Rights. That's the quote here. The next quote is Bruno Simma. Along similar lines, he has called for foreign investors and host states to conduct so-called human rights audits before entering into international investment agreements. The idea would be to survey a host state's human rights treaty obligations and its methods of implementing those commitments before signing an investment protection agreement. That would adjust investors' legitimate expectations whilst avoiding unnecessary constraints on the state's policy-making power to protect human rights. That we have seen. Right. More recently, the PCA docket of investor-state and environmental disputes has touched upon human rights issues. For example, the Yukos arbitrations. The picture here is of one of Michael Khodorkovsky and his business partner Platon Lebedev in a cage in a Moscow court. That judgment, that award in the three Yukos arbitration recently rendered is well known probably because of its magnitude, 50 billion US awarded in damages. But they were part of a multi-forum saga that included two cases before the European Court of Human Rights. This picture shows Mr. Khodorkovsky and his partner Lebedev in a cage while on trial in Russia for crimes including embezzlement, fraud, forgery, and tax evasion. The European Court of Human Rights held that Russia had violated Article 3 of the European Convention on Human Rights, the prohibition of torture, owing to Mr. Lebedev appearing at his trial in a cage, both gentlemen in effect. The Yukos arbitrations have been, while considering the claimant's expropriation claims, has been sensitive to these human rights issues. in effect acknowledging that it was not a human rights court, but still considered the allegations of harassment and intimidation as germane to the expropriation claim under the Energy Charter Treaty. In essence, it recast human rights issues as issues pertaining to the due process of law exception to the prohibition on expropriation in Article 13.1 of the Energy Charter Treaty. The tribunal ultimately found Russia in breach of its obligations under that treaty and awarded the claimants $50 billion in damages, largest arbitral award ever rendered. And to that extent, the Yukos arbitrations illustrate a interrelationship under certain circumstances between investment treaty arbitration and human rights. I move to Africa. This is the border between Ethiopia and Eritrea. That case was brought to the Permanent Court of Arbitration as a result of the Algiers Agreement of December 2000 that followed a ceasefire agreement between Ethiopia and Eritrea, which then was the interim agreement that ended hostilities between those countries that had broken out in May 1998. This Algiers agreement provided for a 5-member boundary commission to delimit and demarcate the boundary, and secondly, a 5-member claims commission to decide claims for loss, damage or injury by one government against the other and by nationals of one party against the government of the other party that are A, related to the conflict, or B, result from violations of international humanitarian law or other violations of international law. In December 2001, both parties filed their claims, and the Commission decided to first examine the prisoner of war games. I leave aside here now the Boundary Commission because that's unrelated to the topic of today. That Boundary Commission was partly successful and partly not. The delimitation was successful, but the demarcation less so. Here you see the Eritrean claim number 17 was brought against Ethiopia in respect of Eritrean prisoners of war interned by Ethiopia. It alleged, among other things, the abusive treatment of Eritrean prisoners of war in Ethiopian camps, the unhealthy conditions and the inadequate medical care in those camps, and the unlawful assault of female prisoners of war. The Commission noted the requirement to treat prisoners of war as human beings as the bedrock on which all other obligations of the detaining power rest. It found Ethiopia liable for abusive treatment of prisoners of war, among other things. This slide refers to the Ethiopian claim number 4, equally in respect of its prisoners of war interned by Eritrea. This slide lists the Commission's findings of liability for Eritrea's failure to observe standards of customary international law, and it really reads like a list of breaches of human rights. Ultimately, the Commission ordered Eritrea and Ethiopia to pay millions of dollars in damages for their treatment of prisoners of war and their failure to prevent other gross breaches of customary international law, including human rights atrocities such as rape. This slide contains pictures of a very interesting arbitration conducted or administered by the PCA, the so-called Abidjan arbitration. You see pictures of the Great Hall of Justice, top left, in its former beauty, and then delegates in the halls of the Peace Palace and delegates in the region, because, and that's why I show it here, there was an example of the transparency that is possible in arbitrations when parties so desire. This particular arbitration, was web streamed. Transparency then. I think this is the only slide that refers to that. Yes. Human rights NGOs have been rather critical of instances where they have been denied amicus curiae participation in international arbitrations. One positive development for human rights in international arbitration has been a general trend towards transparency. In 2013, for example, UNCITRAL, the United Nations Commission on International Trade Law, adopted its rules on transparency in investor-state arbitration. Those rules provide a framework for making information available to the public on investment arbitration cases arising under the relevant investment treaties, concluded after 1st of April 2014. In July 2014, UNCITRAL approved the draft Convention on Transparency, which was adopted by the UN General Assembly on 10th of December 2014. It provides that the UNCITRAL transparency rules will apply to any investor-state arbitration if the state parties to the bilateral investment treaty relied on are party to the convention and have not made a relevant reservation. So it's an opt-in, opt-out system. This helps respond to criticisms of notably investment treaty arbitration that it makes decisions with public policy implications, including for human rights, behind closed doors. As I said, these slides represent an example of a fully transparent PCA-administered arbitration. Video recordings of the proceedings are available on the PCA's website and are even on YouTube. One recent proposal, and I think I'm addressing here the issue raised by Judge Sebutinde just a minute ago on the adequacy of international law when it concerns human rights. One recent proposal for improving access to remedies is the so-called International Arbitration Tribunal on Business and Human Rights. As this slide outlines, this is a proposal for a specialist set of rules, arbitral rules, tailored to business and human rights disputes, which will likely provide for transparency. And I should say that this is triggered in a way by the Rana Plaza factory collapse in Bangladesh in 2013, notably. But to go on with the topics on the slide. Secondly, a specialist roster of arbitrators with a specialism in human rights disputes. And as I said, the characteristics of arbitration, one of the characteristics is that parties appoint their own arbitrators. Thirdly, is a roster of experts on human rights issues who might be appointed as expert witnesses in the proposed arbitration. A registry, such as the PCA, to administer the proposed arbitrations. A fund contributed to by donations from states and individuals, why not, to assist human rights claimants with payments for the proposed arbitrations. And finally, an agreement to arbitrate disputes before a specialist tribunal in supply contracts or after a dispute between the business concerned, the brand concerned, and its subcontractors has arisen. The proposal was formulated by a coalition of lawyers from around the world under the auspices of a London-based NGO, Lawyers for Better Business. The PCA has been approached as a possible registry for such arbitrations. Part of the idea is that the specialist set of arbitral rules the proposal describes could be drafted under PCA's auspices. We are intrigued by this proposal and its potential for enhancing access to justice for would-be human rights litigants. This slide outlines some of the challenges and the possibilities for the proposal, challenges or risks. For example, funding is likely to be a key challenge, but the payoff for the success of the project is improved access to remedy for victims of business-related human rights abuses. Obviously, another challenge is to involve, to get the cross-stakeholder support. That is not a given, but certainly there are certain businesses that are sympathetic to this whole effort and at least interested in the way it develops. These awful pictures of this factory collapse that I just mentioned, the Rana Plaza factory collapse, where over 1,000 people died when the factory collapsed in Savar, an industrial suburb of Dhaka in Bangladesh. The global trade union Industrial described the collapse as the deadliest disaster in the history of the garment industry. 1 month later, over 40 apparel brands, including H&M and Primark, signed the Accord on Fire and Building Safety in Bangladesh, which aims to improve workers' conditions and building safety in Bangladeshi factories and which sets up a Dutch foundation of the same name. Article 5 of the Accord provides for arbitration of disputes arising under it if they cannot be settled by the steering committee of the Accord. Unfortunately, the arbitration clause is not entirely convincing in all its aspects. For example, it refers to the ancestral model law, which lawmakers in national governments can adopt as part of their domestic legislation on arbitration, but it should refer, in fact, to a version of the ancestral arbitration rules, which are selected by parties to govern the conduct of arbitrations. The Accord underlines the willingness of large multinational corporations to subject disputes with serious human rights implications to international arbitration. It also shows the importance of putting in place professional expertise to advise on human rights-related arbitration claims. And then the final slide, in conclusion, I leave you with a quotation from Judge Simma and one of my colleagues at the PCA, Dirk Pulkowski. And you can see there is no return to an international law that puts on an indifferent face to human rights. Human rights can no longer be fenced in an exclusive domaine réservé. Once their genie was out of the bottle, human rights necessarily transcended to the realm of general international law. If the human rights genie was ever in the proverbial bottle at the PCA, it seems clear that it has since escaped. As the 1899 Hague Convention puts it, concern for the welfare of peoples informed the founding states' decision to establish the PCA. As its Secretary General, I venture to suggest that such a concern will continue to inform the caseload of the PCA, and I expect that human rights will transcend the landscape of international law, whether that landscape is fragmented or harmonized. I thank you.